I now recognize myself for 5 minutes. I'd like to specifically talk about the Supreme Court's ruling, the United States versus Texas. President Biden's appointed Solicitor General, Elizabeth Prelogar, made a stunning claim asserting that no state, individual, or business has standing to challenge an administration's decision to, as a blanket matter, not enforce any particular law. When pressed by Justice Brett Kavanaugh if states and individuals were precluded from challenging this lack of enforcement, the president's own Solicitor General responded, "That is correct, but the framers intended political checks in the circumstances. Congress has tools at its disposal." Justice Kavanaugh responded, "I think your position is, instead of judicial review, Congress has to resort to impeachment or dramatic steps in the face of such defiance of the laws passed by Congress." Prelogar's rejoinder was that in the face of dramatic abdication of statutory responsibility by the executive branch, such steps would be warranted. In other words, if the Biden administration's own legal position, it is the Biden administration's own legal position before the Supreme Court that impeachment is proper remedy for dramatic abdication of statutory responsibility. Meaning, if a secretary is not adhering to the laws passed by Congress, the only recourse, because the states now don't have standing, is for the Congress to impeach. That is the rulings of the Supreme Court and the argument brought forward by President Biden's own Solicitor General.
Will the gentleman yield on that point?
I'll finish and then you can be recognized, Mr. Ivey. I think it's pretty clear that in that Supreme Court ruling, the state wasn't given standing. Now, the Supreme Court did not rule on whether or not the gentleman, the secretary, was adhering to the laws or not, but the discussion was about what do you do when they're not? And the conclusion of the court in the majority opinion was, both by Alito and Kavanaugh, impeachment and actions of the Congress are the only place for recourse of a situation like that. That's why we're where we are today. We have a secretary who has, the law is very clear, shall detain. It doesn't say create policies to allow for people to immediately be released in the country. It says shall detain. And that was not done. In fact, systems were created to do just the opposite of that. That is a violation of the Immigration and Nationality Act. It's actually willful and systemic. And when courts ruled you can't do that, he just repackaged it and continued to do just that. And the Supreme Court agrees that the only recourse is for Congress to take action when a secretary, and I will use the Solicitor General's own words, dramatic abdication of statutory responsibility. I yield.